Okay, we'll continue with part 2 of Federalist 83. As you can see on your screen, I have the cover page of one of the books that I've recommended to you. So as we go through Federalist 83, since I'm fortunate to be here at the Library of University of Oklahoma, this is actually the day after Christmas, and I've come up here to do this recording for you. I'll remind you of these books that I have found helpful. Now, I don't agree with everything they say because I'm learning myself. I've read most of these books and I don't agree with everything they say, but then I'm not a scholar of I'm not a constitutional scholar, let's put it this way. I know plenty, but I don't know everything that needs to be known in this subject matter, so I'm learning along too. So let me start with paragraph 2. With regard to civil causes, subtleties almost too contemptible for refutation have been adopted to countenance the surmise that a thing which is only not provided for is entirely abolished. Every man of discernment must at once perceive the wide difference between silence and abolition. But as the inventors of this fallacy have attempted to support it by certain legal maxims of interpretation, which they have perverted from their true meaning, it may not be wholly useless to explore the grounds to the latter. The ground they have taken. So it's good for us to explore the ground that they have put their criticism upon. The next paragraph, the maxims on which they rely are of this nature. A specification of a particular is an exclusion of generals, or the expression of one thing is the exclusion of another. Hence, say they, as the Constitution has established the trial by jury in criminal cases, and it is silent in respect to civil, this silence is an implied prohibition of trial by jury in regard to the latter. In other words, civil cases. The rules of legal interpretation are rules of common sense, adopted by the courts in the construction of the laws. The true test, therefore, of a just application of them is its conformity to the source from which they are derived. This being the case, let me ask if it is consistent with reason or common sense to suppose that a provision obliging the legislative power to commit the trial of criminal causes to juries is a privation of its right to authorize or permit that mode of trial in other cases. Is it natural to suppose that a command to do one thing is a prohibition to the doing of another, which there was a previous power to do and which is not incompatible with the thing commanded to be done? If such a supposition would be unnatural and unreasonable, it cannot be rational to maintain that an injunction of the trial by jury in certain cases is an interdiction of it in others. So he constantly says, just because we said trial by jury in criminal cases is constitutional and we haven't mentioned anything about by civil cases, don't throw that to our face, don't say that we are totally doing away with trial by jury in civil cases. It says that's absurd. The next paragraph, a power to constitute courts is a power to prescribe the mode of trial. And consequently, if nothing was said in the Constitution on the subject of juries, the legislature would be at liberty either to adopt that institution or to let it alone. This discretion in regard to criminal causes is abridged by the express injunction of trial by jury in all such cases. But it is, of course, left at large in relation to civil causes, there being a total silence on this head. The specification of an obligation to try all criminal causes in a particular mode excludes indeed the obligation or necessity of employing the same mode in civil causes, but does not abridge the power of the legislature to exercise that mode if it should be thought proper. The pretense, therefore, that the national legislature would not be at full liberty to submit all the civil causes of federal cognizance to the determination of juries is a pretense destitute of all just foundation. He says we've left it to the national legislature to decide where and in what cases to have jury trial for civil cases. The reason we've done this, he says here and in other paragraphs, is that this thing is too complicated. If for us to have written something in the federal Constitution that would have included every case, this Constitution would be pages and pages and pages long. It'll be complicated, and still we would not be able to cover everything on it. So he says it's not good it would not have been good for us to do this. The next paragraph says, from these observations, this conclusion results that the trial by jury in civil cases would not be abolished, and that the use attempted to be made of the maxims which have been quoted is contrary to reason and common sense, and therefore not admissible. Even if these maxims had a precise technical sense, corresponding with the ideas of those who employ them upon the present occasion, which, however, is not the case, they would still be inapplicable to a constitution of government. In relation to such a subject, the natural and obvious sense of its provisions, apart from any technical rules, is the true criterion of construction. Having now seen that the maxims relied upon will not bear the use made of them, let us endeavor to ascertain their proper use and true meaning. This will be best done by examples. The plan of the convention declares that the power of Congress, or in the other words of the national legislature, shall extend to certain enumerated cases. This specification of particulars evidently excludes all pretensions to a general legislative authority, because an affirmative grant of special powers would be absurd as well as useless if a general authority was intended. So again, he says, we could not write every detail in the Constitution, so we've left it to your national legislature, to the Congress, to come up with the guidelines. And Congress does, when it convenes for the first time in 1789, they write the National Judiciary Act of 1789, which gives the framework of most of the court system that we have right now. In like manner, the judicial authority of the federal judicatures is declared by the Constitution to comprehend certain cases particularly specified. The expression of those cases marks the precise limits beyond which the federal courts cannot extend their jurisdiction, because the objects of their cognizance being enumerated, the specification would be nugatory if it did not exclude all ideas of more extensive authority. Okay, I know the picture quality is not going to be that good, and I've mentioned this book before. It's The Political Theory of the Federalist. It's by David F. Epstein. In the index, on the index pages, it has the pages that different Federalists could be looked up on. But I recommend reading the whole book. And I'll continue showing you different titles. This one is by the University of Chicago Press. I've got to acknowledge the publisher too. And I'll show you some of the other books that I've read. And I feel like it's important that you should take a look at when you decide you want to really spend some time and understand the Federalist Papers a little better.